Well, good morning, ladies and gentlemen, and welcome to this Quadrant Chambers breakfast panel dedicated to offshore contracts and recent developments and trends in relation to offshore contracts. I hope you're all having a good London International Shipping Week. There are very many snappy headings and titles for the talks this week, upside down and winds of change and all that sort of thing. But we couldn't really think of a really good title for ours. Pauline came up with Offshore Talking Heads. I wanted to find out what the origin of Talking Heads was, so I Googled it. There was apparently a punk rock band called Talking Heads. Yes, some people are nodding there. They know much more than me. With snappy titles like Psycho Killer. I don't think that's for today, but I noticed two of their hits were Once in a Lifetime, and I hope that's going to be right today, and This Must Be the Place. Seeing you're all here, it plainly is.
Road to Nowhere.
Road to Nowhere, thank you very much. There's always a heckler. And imagine having to sit behind him. He's a sort of nightmare in the cinema or the opera house. So let me introduce who we are. I'm Simon Rainey KC. I've specialised in these sorts of contracts for many years, and I'm the author of Tug and Tow and Offshore Contracts. Shameless plug now, new edition coming out in March, April, audio copies now. I'm joined by Paul Dean, the head of global shipping at HFW, who has been described by me actually as the guru of offshore contracts. And he is very intimately involved with the drafting of forms. For example, the UK standard conditions for towage, the new edition last year, and snappily the latest BIMCO form for dismantling offshore objects, DismantleCon, I believe. No one has as many supply time 2017 cases as Paul. Next, we have Helena Biggs, Senior Legal Advisor at Gard, with a wealth of experience on the P&I side of these sorts of offshore contracts, and with the interface with the so-called specialist operations exception, which you might be hearing about this morning. And last but not least, Andrew Leung from Quadrant Chambers, one of our best senior juniors, with plaudits. Yes, well, he looks young, but he's pretty senior. With plaudits in all the directories. I always like quoting one of these. Advocacy skills beyond his years. Well, ladies and gentlemen, you'll be the judge of that. So we'll have questions at the end. There'll be a roving mic. Please put your hand up. And then any difficult questions I will allocate to the other speakers. So let's throw it open. Paul, you're really at the coalface advising offshore clients long before disputes even arise. What sort of trends are you seeing in the contractual space?
Thanks, Simon. Well, first of all, good morning, everybody. It's a real pleasure to see so many of you here today. I think before I answer that, Simon, I'm just going to begin with a little bit of history in relation to my involvement with these contracts. And it goes back to 1988 when I first started working on these contracts. And yes, if you're guessing, I was 11 at that particular time. Now, at that particular time, we were looking at the supply time contract was the 1975 form, and I did have a case involving that form many years ago before it evolved into 89, 2005, etc. But also tow-con and tow-hire as well. And actually, the first time I came across Simon was on the other side from me on a case called the Herdentor, which I think we may touch upon a bit later.
I had hair then.
I think both of us had more hair at that particular time. Since then, I've done a lot of teaching, and I can see colleagues around the room. I can see Robert Gay, for example, that we've done courses all around the world in relation to the using supply time course and other things. And people remember me for the turtle story. If they remember nothing else, they remember the turtle story. Not necessarily what it said or the outcome of that case, but they remember the story. And I think it's fair to say that we've seen an evolution of knock for knock over the last 30 years or so. The principle is really, really easy. Your people, your property, your problem. So that's it, right? End of conversation. No, not necessarily. When it works, that's it. That is the end of the story. But I think it's fair to say, as Simon was asking initially, there have been emerging trends where not for not does not necessarily work. And I think The first example that I would suggest is the 2017 form. I wasn't involved in the drafting of that, but very soon after it was drafted and it was released, I was contacted by the head of Offshore at the Ship Owners Club. And he said to me, can you have a look at the group definition? Back. Do they cover everybody? So I looked at it and my conclusion was, no, they didn't. So there was a big, potentially a really big gap in relation to who was captured. So I think that's emerging issue number one. I think emerging issue number two, and this is really, I would suggest, has developed from the civil law systems, particularly in Europe, is where parties are carving out gross negligence and willful misconduct, because in those jurisdictions you can't exclude liability for those particular issues. And Helena and I have discussed that issue at length relatively recently, actually. I think also another trend that I have noticed is that you're getting parties effectively including deductibles before the knock-for-knock applies. So that's something else that we've seen. But I would suggest probably the most interesting development, which is I've observed in the last few years, has been involving the entire agreement clause, where there have been...
Just raise your voice.
Oh, sorry. Forgive me. Can you hear me clearly at the back? Good. Max can hear me. If Max can hear me, everybody can hear me. Thanks, Max. So the entire agreement clause, where there are allegations that there have been perhaps negligent misrepresentation in relation to the capabilities of the vessel, are those misrepresentations automatically excluded because of the knock-for-knock regime? Does the entire agreement clause cover them or not? And Simon, I think this is an example of a thorny issue in the last edition of your book, and I don't know whether you're going to mention something similar in the next edition, which you have shamelessly plugged.
Excellent book. A snip at 400 or whatever it is.
You refer to me or us as working together on many thorny issues. I'm just wondering, is this a thorny issue that has crossed your desk?
Yes, it has. And I think it's interesting what you say about the trends that are developing. I think given the complexity of offshore operations, particularly offshore project operations, they seem to get more and more complex with each year, and the huge value of the projects, I think two trends actually stay constant. The first is the search for ways around knock-for-knock, either by the special drafting of provisions that, like Paul's been discussing, so a hybrid knock-for-knock with knock-for-knock over a certain amount, but not knock-for-knock under a certain amount, or limitation of liability provisions, or by ingenious and not very ingenious arguments trying to pick holes in the BIMCO forms. I'll come back to the BIMCO forms in a minute. The other trend is to try to maximize the operation of knock-for-knock by trying to shoehorn liabilities into it. I think Paul's given a very good example, the need to try to put misrepresentation claims within knock-for-knock, and something we might come back to a bit later. Two aspects I think are worth noting here. Paul says, well, I've got a knock-for-knock clause, so I'm okay. And there is an approach that says, well, it's a BIMCO contract, so we all know what that says. But the trouble with that is, which BIMCO contract are you using? And the even bigger problem is which version of the BIMCO contract you're using. People in the marine industry are quite slow to take up new forms, but there is a ceaseless change in BIMCO forms. TOCON Tow Hire 2008 has just given way to TOCON Tow Hire 2021. The REC stage form has now been revised 2024. There's a new supply time variant for the hot topic of accommodation support vessels, ASV time, that's also 2021, and a new barge hire form 2021. It's really, as an author on these forms, it's really very difficult to keep up. But something that I think is very important to bear in mind is each form and each revision has a different drafting committee. So you've got different drafting committees approaching the same legal problem, which comes up in a series or suite of contracts, and they're approaching it sometimes in a different way with different language. And that can lead to different results, which I think push people to look for ways around the not-for-not clauses. Let me give 3 examples of inconsistencies. Barge hire, a really exciting form, a demise charter for barges. The original form excluded liability for delay payments if there was gross negligence or willful default. Okay, we all know what those terms mean, and Paul's just touched on. The 2008 barge hire dropped the word gross, so it just said negligence and willful default. And the explanatory notes, there's always a good joke in the explanatory notes of a BIMCO form. Sorry if any BIMCO people here. But we've dropped the word gross because no such concept exists in English law, which is news for English lawyers. And then take the 2021 revision, where without any explanation at all, gross gets slotted back in. Look at the huge varieties of not-for-not clauses in the form, TOCON, supply time. They're all slightly different. If you use a 2008 form, you're going to be taking a very different approach to consequential loss and not-for-not. And then Paul has mentioned entire agreement clauses. Part of every modern contract, we all know them, especially in the offshore industry, is an entire agreement clause, usually trying to tackle things like misrep. The BIMCO forms are way behind. There are very, very few BIMCO forms with an entire agreement clause. Supply time 2017 has one. I'll come back to it a bit later, probably. It's not a very good one. And at last, Barge Hire 2021 has got a working, proper example of an entire agreement clause. That's the first aspect I think we need to bear in mind in these offshore disputes. The second aspect, and I think Andrew and I may differ on this, the second aspect is the continuing shift in English court cases, taking a less restrictive approach to construing exemption clauses and exclusion clauses, especially when they're mutual clauses, mutual risk allocation clauses, like we have in the not-for-not clauses. And I think that has the effect of bolstering significantly not-for-not and its efficacy, at least, and that leads, I think, to the attempts to carve things out. I'll probably talk a little bit later about a very important case which the Court of Appeal decided, judgment handed down in July of this year, EE Mobile and Virgin Mobile, which actually touched on the TOCON cases and the supply time cases. First time I think they've been mentioned in the Court of Appeal for a very long time. But I said that you and I are probably on slightly different pages. What do you think?
Well, I suspect we're probably more aligned than you think, Simon. So as part of the less restrictive approach that's now being applied, the courts and tribunals are increasingly willing to find that especially egregious forms of misconduct fall within and are exempted by not-for-not provisions. If one goes back to concepts such as gross negligence and willful default, it's true, gross negligence has been much disparaged by English lawyers. I think it was Lord Millett who once said that English lawyers have a healthy disrespect for the difference between negligence and gross negligence, which didn't stop another judge from trying to explain that gross negligence means a very bad case of negligence or even great negligence. Anyway, leave that to one side. Willful misconduct has a bit more legal content. It's even more beyond the pale than gross negligence. It means misconduct far beyond negligence, even gross negligence. And make of that what you will. And there are authorities which suggest that willful default requires a deliberate breach of duty. Now, it was established in a 2004 case, Transmars, that there's no need for a limitation clause, at least, to refer expressly to willful default in order to limit liability for it. The court held in that case that since the clause it was considering limited liability howsoever arising, it covered liability for deliberate wrongdoing. And the court came up with this rather circular proposition. Words mean what they say, and the parties will be held to the bargain into which they have entered. In an arbitration I did recently with a colleague from Chambers, Nigel Cooper, in which, in fact, Paul and Simon had some involvement, but fortunately we weren't directly against each other, and we had the opportunity to run a similar argument. So the dispute was whether clause 14b of supply time 2017 excluded an owner's liability for gross negligence or willful default. And the allegation being made by our opponent charterers was that the owners had engaged in reckless or willful misconduct because they'd engaged hopelessly incompetent crew who had no idea what they were doing and had made serious and foreseeable mistakes, which had caused tens of millions of dollars of damage. Now, Clause 14B of Supply Time 2017 makes no reference to gross negligence or willful defaults. And Paul, I was pleased to hear that you weren't responsible for the drafting of this particular form. It has some rather ornate provisions. So Clause 14B, this is the only clause which I think anyone is going to have to read out this morning, I hope. It excludes liability for losses arising out of or in connection with the performance or non-performance of this charter party whatsoever, and in any circumstances, even if such loss is caused wholly or partially by an act, neglect, breach of duty, or default. And you won't be surprised to hear that the tribunal didn't have much time for the suggestion that those rather wide words didn't encompass gross negligence, let alone willful default. And there are just a couple of points which I find interesting and which are worth highlighting. So neglect or default, according to the tribunal, included negligent acts, including those which were deliberate and therefore grossly negligent. The tribunal wasn't prepared to find that neglect or default extended to willful default. And so there was a distinction between those two concepts, but willful default was encompassed by the concept of breach of duty, because you can breach a duty willfully or otherwise. And so this seems like a fairly sensible outcome. And if anyone ever tries to argue that knock for knock doesn't exclude liability for gross negligence or willful default before a different tribunal, I think they're going to have a hard time doing so. But
It was quite a distinguished tribunal in that case, wasn't
it
it?
was a very distinguished tribunal consisting of no fewer than 4 former Court of Appeal judges. There were 2 concurrent arbitrations, and it was a bit like a time machine. 2005, I think, is when they were all on the Court of Appeal together. But Helena, my understanding is that liability for willful misconduct and gross negligence is generally not covered by P&I insurance. I'd be interested to hear your thoughts on that.
Thanks, Andrew. Yeah, that kind of goes to the conversations that I was having with Paul a little while ago, and I'll come on to that towards the end of the bit that I've got to say. But just to start with, obviously there's, when you're negotiating contracts, the focus is very much on risk allocation between the contractual counterparties. And I think sometimes people don't have in mind so much the insurance requirements that sit behind those contracts, and which obviously cover the liabilities which come out of those contracts. So I thought perhaps it would be useful just to explain in broad terms how P&I cover and insurance cover generally works, so that people can have that in mind when you're looking at contracts for your commercial clients. The offshore industry is quite a complex area in terms of the insurance cover, because you will have what we call the mutual P&I, that's the international group sort of bit of the product, that will cover the ships when they're going to and from the site. But the specialist operations which are associated with the offshore industry are subject to an exclusion. So then you're looking at buying fixed premium products from the insurer. So there's 2 different types of insurance that are involved in making sure all your risks are covered in the offshore industry. As far as mutual P&I is concerned, it's predicated on legal liabilities. So that's to say liabilities on tort and liabilities that come out of the statutory framework. And it responds to the specific named risk. So what I find interesting, I guess we all do it with our, we sign our terms and conditions. When you're being asked to do so by Google, you don't necessarily go through them. It's worthwhile at least having a look at the index to a set of P&I club rules to just get a handle on what risks are covered if you have any, if you're not sure. It doesn't, importantly, respond to contractual liabilities, and it will only do so if the particular forms have been, or contracts have been reviewed and approved by the P&I club. Now you can imagine if P&I clubs were saying to people, we want to see every single contract that you sign off on, that's going to create a huge administrative burden. So a sort of shorthand, if you like, is that we generally will accept standard form contracts such as BIMCO supply time contracts. And that keeps things straightforward. Where you're getting into negotiating very bespoke contracts from scratch, it's a lot more tricky, obviously, because we have to look at them and we have to go through them to check where there's sort of issues potentially with P&I covers. So I think if you're either amending standard form contracts or you're starting with a fresh sheet of paper, the thing to bear in mind is that if you are going to be departing in any way from a fault-based approach, then you might be wanting to have a conversation with your P&I club as you go. A lot of the time we see contracts coming in that have already been signed. I get it, you know, that's commercial bargaining power between the parties. You might not be able to, you know, protect your position as fully as you'd like to. But obviously it makes sense from a P&I underwriter point of view that if you can be involved as you go along, you can just help people navigate any issues, make sure they've got the right insurance in place, or at least make informed decisions. Where they can't get insurance from us, maybe they can go to the market and source it from elsewhere. So to give you an example, if you had a contractual counterparty accepting responsibility for risk, which would usually lie with their the other party to the contract, you know, that's the sort of issue where you want to be coming and talking to your underwriter to make sure that they can cover it. In addition, you know, by dint of the fact that it comes out of the wider legal framework, you know, we're happy with that, we're comfortable with it. There are some baked in assumptions when the clubs are underwriting these risks. So probably an obvious thing is that we would expect people to preserve the protection that they're entitled to as a matter of right and law. So if you are looking at contracting out of limitation regimes, for example, then that's something which you're going to have a conversation with your underwriters. It's actually written into the club rules that you don't waive rights of limitation. You're expected to preserve them. But, you know, there are other products, again, the non-mutual side available that can help, or at least to a certain, you know, to the policy limit, whatever you fix that at. So you can help get some insulation from it. There's also an expectation that you won't be waiving rights of recourse against third parties, you know, to prejudice your subrogated underwriters' rights. So again, if you're looking at waiving rights of recovery, then you should be having a conversation with your P&I underwriters. That said, in the context of the offshore industry, obviously not clauses have been around for a long time, and P&I clubs like them because as long as they're mutual, then it massively reduces our exposure through any contractual liabilities. It's not to say though that the clubs won't accept other allocations of risk, but what they're looking for is very much a sort of balanced approach and a symmetrical clause. If it's asymmetrical and everything's with R assured, then we're likely to see that as what we call an onerous contractual liability. And just picking up on the point that's been made here a few times in terms of willful misconduct and gross negligence. So Paul and I, the specific case that he was referring to was a slightly unusual case in that it had a carve out of willful misconduct and gross negligence, which I, in my layperson's mind, sort of equate broadly to recklessness, I suppose. And interestingly, it was subject to English law, so it didn't need to have those carve-outs in order to be, you know, to work as a contract. But it did give rise to quite a few discussions around the extent to which it could be covered by the club. And I think the answer is to pick up on Andrew's point, really, it really comes out of what is held to be willful misconduct or gross negligence. And just because you have a court deciding that a particular act is willful misconduct, you know, I think as an underwriter, you would look at that independently and you would form your own view. And if it didn't fall within that category as we would see it, then you're fine. But I think what you can say is it certainly creates or introduces a degree of uncertainty about how your insurance cover is going to respond to that carve out. So it's a real dilemma when it's necessary, you know, in some jurisdictions under some laws for that whole not for not clause to be effective. But then, as I say, it's taking into contractual uncertainty, which people don't generally like. Or did you want to pick up that?
No, thank you very much, Helena. Actually, I wanted to pick up first of all on something that Simon said about the BIMCO notes. And I'm reminded of something that Julian Flo said about the BIMCO notes, which was everybody knows you cannot rely on the BIMCO notes. I thought it was quite interesting.
That is on that Norwegian sail form case, wasn't it?
Correct.
Yes, he was
correct.
very, very rude about the explanatory notes.
Yeah.
Be rude about most things, but
I think just coming back to how these issues evolve, and I think that's interesting in terms of the new forms which come out. And I just wanted to revisit what happened in relation to supply time 2017 and the realization that the group definitions didn't work. And we're very lucky to have here today Robert Gay, who was at one of these courses where I revealed to Ian Perrott, who was the chairman of the drafting subcommittee, sorry, Ian, there's a whole chunk of people who have missed out from your new group definition clause. And after trying to argue with me, you could see he sort of deflated completely. I did come up with a solution, but I also came up with something which illustrated the problem. And I can see Nick Kazaz is here. Nick may remember that behind my desk at work, there was this huge drawing that I'd done to try and work out who was included and who wasn't included. Obviously completely useless in terms of marketing material. So to do something else which is completely shameless as well, I think these are about 10 pence on eBay. I came out with this iPad, this mouse pad, which reveals everything. I think, Simon, I gave you one of these.
no, I never have, and I want one immediately.
I think the price has
I'll
just
take that
gone
one.
up to about 15 pence on eBay. But the good news is that there is a solution to that hole. And if anybody wants that, then just let me know. I'll give it to you. I'm also reminded in relation to the case that Andrew was talking about, there are quite a few people in this room who were involved in that case, which also reminds me that we're in a room full of lawyers. So whatever I say, I've got to be really, really careful. I think the trend which is coming through most forcefully for me at the moment is involving the entitlement agreement clause. It is involving misrepresentation, particularly in relation to supply time 2017. And in terms of a war story, I had a case relatively recently where there were allegations that really crucial equipment, which was the purpose of the charter party, had existing faults prior to the vessel being contracted. So there were questions as to whether there were, whether it was negligent misrepresentation, therefore requiring an investigation of the facts, all of these sorts of things. And I think this is important in the context of a pure not for naught, where you do not need to investigate the facts. Everybody knows how the fault lies. So I think that was a turning point. But what is also interesting for me is I've actually seen this argument. I've got two current cases, big cases, where this is a live issue. And Simon, I'm going to return this back to you as a thorny issue.
Better be careful what I say then. No.
Yes, indeed. But it is a thorny issue.
It is a thorny issue. I think a misrepresentation, usually simple negligence or contractual sloppiness, can be a real problem in the offshore sector. And you see the concentration on relevant information about the vessel you're going to be using and its capabilities, the services you're going to be providing, the site of operations, if you're talking about Project Con or the rec forms, a lot of concentration on the provision of accurate pre-contractual material, which is then incorporated into the contract in annexes. Take, for example, Rec Stage 2024, which is the start, I think, of the review of all of the rec forms by BIMCO. Oddly, they've done Rec Stage separately from Rec Con and Rec Time. There are now 3 annexes in exceptional detail to describe what the services are, what the site is, what the changing conditions at the site are expected to be, what the range of options are, and so on. Paul's cases, which involve the argument that by the misrepresentor that the loss or damage sustained as a result of misrepresentation can be squeezed in somehow under the cover of knock for knock. Why does that argument come about? It comes about because most offshore contracts, as I said at the beginning, and particularly on BIMCO forms, don't have entire agreement clauses unless the parties have specifically added a rider. And it is surprising that even in the latest revisions of the BIMCO, 2021 revisions, for example, of the towage forms and the barge hire form, in the towage forms, there's no entire agreement clause. The drafting committee simply hasn't thought about it, whereas the barge hire form there is, in the supply time form there is also. And I think the problem, what makes these arguments come about is a failure to have an efficient entire agreement clause. So the misrepresentor has to find some other route to get himself off the hook. Take two examples of the only entire agreement clauses in the offshore forms provided by BIMCO. The entire agreement clause in clause 38 of Supply Time 2017, I'm very glad to hear that Paul wasn't involved in the drafting of that, hasn't in fact been updated since the Supply Time 89 and Supply Time 2005. It's a very, very old entire agreement clause. You don't need to tell me, there's so many lawyers in the room, how many cases there have been on entire agreement clauses and whether they cover negligent misrepresentation. So, for example, AXA Sun Life and Campbell Martin. And so an entire agreement clause that reads, Andrew said we wouldn't have any more clauses read out. I'm going to try and read my own handwriting. This is the entire agreement of the parties which supersedes all previous written and oral understandings. Useless, quite useless for negligent misrepresentation, almost the same wording that was considered by the Court of Appeal in AXA Sun Life, and Campbell Martin said it doesn't cover negligent misrepresentation. And a leading London arbitration tribunal in 2005 found precisely the same on the supply time form. No change has been made by BIMCO to that entire agreement clause. Compare at last barge hire 2021. You see, I'm very fond of the barge hire form. Clause 32 is a really detailed, modern entire agreement clause. You could actually copy it and use it in any other contracts. It's a good entire agreement clause. So you have these words at last. Each parties acknowledge that it has not entered into this contract in reliance upon and will claim no remedy in respect of any representation, warranty or statement unless it is expressly recorded in this agreement. And that's a pretty good clause. So what about the argument that comes up in Paul's case is, can you squeeze liability for loss caused by a misrepresentation inducing you to contract within the words that Andrew read out, clause 14b of the supply time form, a loss or damage arising out of or in any way connected with the performance or non-performance of this charter party? Well, I'm not going to express a concluded view, but I would suggest that that doesn't really easily sit well with loss due to the wrongful inducing of a party to contract. It's dealing with performance and non-performance of contractual obligations, not the negligent, tortious inducing of the contract, which is then either performed or not performed. That would be my provisional view, but I'm open to discussion with anybody else. Andrew, what would you like to add to this?
I want to discuss briefly the limits that even a well-drafted entire agreement clause can run up against in terms of the protection it affords. And I'm going to do that in the context of class certificates. So an argument which sometimes comes up in these sorts of cases might arise as follows. So let's consider a vessel which is in class, it's seaworthy, but it has a defect which class hasn't discovered. It's a not uncommon problem. Now, in this scenario, the owners of the ship provide this clean class certificate to the charterers before the conclusion of the charter party. And it seems self-evident that the provision of this certificate could amount to a representation by the owners that the vessel is in class, so far as the owners are aware. But is it also a representation that there are no other defects that might have affected the vessel's class status when the certificate was issued, of which class was unaware? And you might ask, well, what is the point of a class certificate if it's not accurate? If there's some unknown problem, which means the vessel might not have been given class's seal of approval after all. And is a provision of a certificate not just a representation that the vessel has a clean bill of health, but also that the clean bill of health is deserved and valid? Now, against this, I think we all know that class certificates don't operate as guarantees. Class doesn't necessarily check everything. Class makes mistakes. There's a rather amusing case from the 1980s called the Buena Vista, where there was lots of evidence about Lloyd's Register in particular. And it turns out that the experts on both sides agreed that while the rules applied by Lloyd's suggest owners should really disclose defects when they discover them, the reality is rather different, and the owners just leave it to class to find what they can. And if they don't find other issues, well, that's class's problem and nobody else's. Well, I'm not going to express a concluded view on whether the provision of a class certificate amounts to a foolproof representation that all is well. But I want to add a wrinkle to this scenario now. Let's now assume that before the charter party is concluded, class carries out a further survey, discovers hitherto undiscovered defects, and imposes conditions of class. And that's a change in circumstance. The original certificate has been overtaken, and it might be said that the original representation by the owners who provided the previous certificate, stating that the vessel is free of conditions, is no longer true. If the charters aren't updated, there's more scope for alleging misrepresentation. Now, the point here is that in various other contexts, it's been held that a failure to reveal a fact previously stated is no longer true, has been held to be fraudulent. And as we all know, you cannot exclude liability for fraudulent misrepresentation. Even the best drafted entire agreement clause won't do that. The distinction between negligent and fraudulent misrep is normally irrelevant if you're claiming damages, thanks to the 1967 Act, because you can claim damages for negligent misrep as if it were fraudulent. But if you are running up against an entire agreement clause as a party alleging misrepresentation, it may still be possible. It may still be necessary, in fact, to establish fraud if you're not going to be bought out by an entire agreement clause. I'm going to hand over to Helena now.
Actually, I don't know if you wanted to come in on.
I'll catch it.
You'll
I'll catch
catch
it.
me. Okay.
Always been thrown down.
Don't throw it back to me.
Well, I may come back to you, but we'll see. No promises. What I do want to say, which is I think is really quite amusing, is Andrew said it, Simon said it. No concluded view. We have to all remember that. Maybe we'll have a concluded view in TNT5.
Well, you need to buy it.
Oh, okay.
I might even give you one.
I might get a
this.
discount. Okay, all right, okay. I just actually wanted to pick up on something which Helena said, which was that we see not-for-not provisions where there is a variation in terms of the allocation of liability. And of course, I think we need to remember that there are commercial influences at play here. And one of the things that we do see, and I suppose I'd best describe it as like a hybrid not-for-not clause, where one party is trying to effectively lay off their deductible. Their deductible could be $1 million, for example, in relation to a particular property liability. So what they try and do is they'll amend the not-for-not provision so that the first $1 million of any claim that relates to their property, their people, it is picked up by the other party. And in relation to that, in some ways, I guess that's a bit of a limitation issue, Andrew. What do you see in relation to limitation issues?
Well, there's lots of authority to the effects that limitation clause aren't viewed with the same horror by courts and tribunals as exclusion clauses. They're treated as an allocation of risks and benefits, and the parties should be free to make what allocation they wish. And this distinction between limitation and exclusion clauses came to prominence in a case called Ailsa Craig Fishing, where the House of Lords considered a limitation clause which caps liability at £1,000. I don't know what inflation has done to that sum, but it still seems like a rather small amount of money. Now, what happened in that case is there was a failure to provide the services contracted for, namely security cover for certain fishing vessels, one of which sank. And the House of Lords held that despite the clause, the limitation clause, making no reference to negligence, and despite the contracts being condemned by Lord Salmon as deplorably drafted, the clause was nonetheless effective to limit liability for negligence. And Lord Fraser noted the inherent improbability of an innocent party intending to release a party in breach from liability, but added that no such improbability applies to an agreement merely to limit liability. And Lord Wilberforce went even further. He held that the limitation clause was effective even where the negligence giving rise to liability consisted of a total failure to perform the contractual services. Now that's in stark contrast to a case which Simon is going to discuss shortly, a turtle, where Mr. Justice Tier effectively said, if you're not performing at all, then you can't be exempted from liability. Before we move on to the turtle case, though, I should say that it's been doubted in more recent cases whether there really is a rigid distinction between limitation and exclusion clauses. The better view is that the more extreme the consequence of limiting or excluding liability, the more stringent should be the court's approach. And recent cases, such as Triple Point, suggest that the modern approach, which recognizes that the parties can allocate risks however they want, applies to both limitation and exclusion clauses. But despite that, there's a very recent case I chanced upon from just last year, Innovate Pharmaceuticals and University of Portsmouth, where the judge suggested that there is still increased hostility to exclusion clauses as compared with limitation clauses. So the cobwebs of that approach have not yet been fully swept away.
That's a TCC decision, isn't it?
I think it is, yes.
Well, there you are then.
Well remembered. Which raises the question, if there is still this lingering difference in approaches to limitation and exclusion clauses, how might that apply to a hybrid not-for-not clause, which, after all, there's a marriage of both types of clause? And it seems to me that it would be a little strained to construe a hybrid regime using a two-track approach. It's hard to see why one limb, the limitation limb, might attract less hostility than the exclusion limb when they're part and parcel of the same machinery. So I suspect one thing to look out for is whether courts and tribunals, when they come to wrestle with hybrid not-for-not provisions, decides that there is in fact no distinction at all between the approaches that should be applied. Now, I've said a bit about hybrid not-for-not clauses. Simon is going to tell us now about when not-for-not clauses are not-for-not clauses.
Well, the answer to that question is a short one. When it is approached in line with the old decision of Mr. Justice Tier in the A Turtle, it's a case that Paul and I are very fond about. Many of you will be familiar with the decision. Whenever I'm talking about the A Turtle and I have a PowerPoint presentation, I usually at this stage put up a picture of the tug in question, which was inaptly named the Mighty Deliverer, who instead of delivering the tow to Cape Town, abandoned it in mid-voyage, and it can be found on a website which lists the ugliest ships in the world.com. It really is a grotesque piece of naval architecture. In the A Turtle, Mr. Justice Tier held that the breach, which was the act of the tug owner setting off across the South Atlantic with insufficient bunkers to reach Cape Town, so she had to slip the tow mid-voyage, was so, in his words, radical that it did not fall within the not-for-not regime. That came, I think, as a bit of a shock to most not-for-not lawyers, because to give the not-for-not effect would be to deprive the hirer of any real remedy for that particular breach. If you like Latin, this is called the nudum pactum argument. In other words, the clause is so wide that by depriving the person of a proper remedy, it makes the contract a mere declaration of intent. I've always thought that's obviously wrong, and I slammed it in the 3rd edition, I slammed it in the 4th edition, and I've slammed it even more in the 5th edition. It's obviously wrong, since the not-for-not doesn't wipe out all remedies. It simply wipes out certain remedies for certain types of loss. And that was the obiter view of Mr. Justice Clerk, as he was in the Herdentor. But the Court of Appeal has come to the rescue, and there's a very important case decided, as I said at the beginning, July 2025, EE Mobile and Virgin Mobile, in which the Court of Appeal has completely reappraised the mere declaration of intent argument. In other words, the argument that clause deprives me of an effective remedy, therefore it can't have that effect. And the Court of Appeal held that it's not a question of looking at the particular remedy being sought and whether that is an important remedy which is being excluded. It's not a question of whether the remaining remedies are sufficient or not, or fair, or represent proper remedies. You have to look at whether the remedies, some remedies, exist. For example, can you seek a declaration? Can you seek an injunction? And so the approach of Mrs. Justice Carr in the Fujitsu case was upheld by the Court of Appeal. But it can be a very tricky question. But I think the Court of Appeal decision really underpins now not for knock, and I think it makes it very difficult for the A turtle decision really to stand. It just doesn't. It never really hung together, but it doesn't hang together now in the light of the very clear approach taken by the Court of Appeal. But as I said, it can be a tricky question. The Court of Appeal split 2-1. And Lord Justice Phillips took a very narrow approach, rather like Mr. Justice Tear's approach, really, in the A turtle, when he said it was right to focus intently if the parties intended that enforceability of an important obligation, seaworthiness in a tow conform, a towworthiness in a tow conform, would be significantly undermined by the exclusion clause in question. I.e., you've got some remedies, but they're not really the remedies you want. You've been deprived of that remedy. And there was a really, really tart dissent from Lord Justice Phillips in that case. So also look at that. I think we're running out of time. So also look at that case. There's a very, very useful discussion. Not for not clauses always exclude loss of profits. The TOCON 2021 form extends that to loss of profits and loss of anticipated profits. There's a very good analysis of what loss of profits and loss of anticipated profits means by the Court of Appeal in that case, who are rather dismissive about the two towage cases and supply time cases, the Herdentor and Easefaith, but I'll leave you to catch up on that in your own time. I think that's probably the end from me, Paul, but as you're an A-turtle man, would you want to say something about that? I know it's very dear. It's as dear. I'm sorry, I mustn't touch my mic. It's as dear to your heart as it is to mine.
Yeah, it's been there's been much entertainment in relation to that case, particularly the uglyship.com analysis of the mighty deliberate. Yeah, wholly inappropriate for that particular job. And there's some amusing anecdotes in relation to that particular voyage. There was one particular day when she was being towed backwards at a speed which, if it had been the other way around, should have actually got to the destination purely by the process of the sea and the tide. And I'm also reminded that you and I wrote an article, a joint article in Lloyd's List, which was extremely critical of the case, and Mr. Justice Tear has never spoken to me since. So I think he's spoken to you, Simon.
Yeah, well, he's very kindly agreed to write the foreword to the fifth edition. So I'm very, very lucky. Oh, that's absolutely right.
Are you writing a forward or a defense of A turtle?
We'll see.
I think Robert's absolutely right. Read it carefully.
Yeah, okay. Right, well, I think that's probably coming to the end of our
Yeah.
session. We're very happy to take questions. As I say, any difficult questions. Oh, I'm not. Can we put your hand up? State your name and where you're from, and who's on.
Robert Gay, I'm an LMA arbitrator of sorts. I'd like to ask two questions of Paul. One of them is simply, you started with 4 trends and I missed the third.
I think you may have missed the fourth, which was in relation to where parties are trying to alter the limitation of liability amounts under the LLMC. We didn't talk about that. I have observed it relatively recently. There was a case where the parties did try and amend the LLMC provision and attempt to increase limits. It didn't work. And the reason it didn't work was because you have to use extremely precise words. That was made clear in the Cape Bari decision. So that was the last one.
And the other one, suppose the supply time, the latest version, 2017, suppose the vessel with really expensive charterer's equipment worth much more than the vessel requires salvage.
Yeah.
Does the knock for knock apply so that each party pays the salvage based on the value of its stuff? Or is the general average and then the parties have to pay GA contributions? Answers on the back of a postcard.
Robert, honestly, to ask a question like that.
Fantastic answer.
What I get to do is I get to adopt language used by both Andrew and Simon, which is I'm not going to offer a concluded view, but I'll go back to very basic principles of salvage. I would have thought that if it's charterer's equipment, all the values would be put together, and it's whose the value of whose particular equipment. In terms of the not for not, I think that's a cold towel analysis. What is your view?
Is the supply time 2017 fails to exclude the operation of Finland?
Right. Okay.
It would slightly depend what the salvage contract was, because if it's Lloyd's open form, then each property owner is a party to the contract and they pay according to value. If it's a wreck hire or something like that.
Speak up, Robert, but then we don't need the mic. Stand up. That's good.
I've seen cases not under supply time where the parties paid their salvage up by its own form, and then there was a GA adjustment which reallocated it. And I think, formally speaking, my question is, where do you end up?
Cold towel.
Well, if there's a GA adjustment, you would expect that to be done by value, but
Yeah,
because that's what
exactly.
GA was saying.
My stock answer when I get a very difficult question is to say, I'm terribly sorry, that seems to be very close to the facts of the case I'm currently advising. Always works. Any more questions? Right, well then, may I ask you all to join in applause, not for me, but for the other panel members, please?